Hearing will start now. This is originating applications 381 to 385 of 2022, summonses 2684 to 2688 of 2023, and originating applications 757 and 758 of 2023, Zipmex Company Ltd and other matters.
All right. Mr. Jonathan Tang and Ms. Carissa Lau for the applicants, correct?
Yes, Your Honor.
Well, let me and Mr. Zoom elocution. Parties reminded there is to be no unauthorized photography or recording of any form and no dissemination of any photographs or recording of these proceedings. And only those counsel or persons notified to the court should be present at each location, and parties should treat these proceedings as they would a physical hearing. All right, Mr. Tang, we are here this evening for your applications in OA 757, 758, as well as the consequential extensions of time. Can I confirm that there have been no indications of any opposition from any of the creditors?
Your Honor, there has been one indication of opposition to 757 by the secured creditor, which I intend to go into at the hearing itself.
But they're not present here, are they? Aren't you?
They are not present, no. Raja and Tan is not present. In terms of unsecured creditors for Zipmex Singapore, we have counted one Crisada Depatch as being in opposition, and this was because she had written to the court, Your Honor, and the content of her email seemed to indicate an opposition to 758.
All right, sorry, hold on. This is Miss Siripon, right?
No, Your Honor.
Sorry.
Yes.
What's her name again?
Crisada Depatch, I believe it's a lady. So it's Miss
Depatch. All right. Hold on a moment, please. Right, I don't believe Miss Depatch is in attendance this afternoon. All right. Then.
No, I do not believe so.
All right, then. All right, let's proceed then. Could you summarize your position in relation to the applications, please?
Yes, Your Honor. Before we proceed, Your Honor, maybe I should just give a very brief overview of how I envisage to proceed with this hearing, Your Honor. So there are basically three buckets of applications before the court, as Your Honor had rightly mentioned. The leave to convene applications, which I intend to deal with first. And then we have the variation and substitution application in OA 758. Yes, Your Honor, 758 regarding variation of the POTSA requirements. And then finally, we have the extension application. So maybe if I can proceed in that order, if you please.
All right, yes.
Thank you, Your Honor. First, Your Honor, on the leave to convene, I don't suppose Your Honor would want me to run through the law.
No, you can summarize where you are at and what you propose to do next. Thank you.
Yes, Your Honor. So essentially, and maybe at this point, it might be good to take Your Honor to Annex A of the written submissions. It's right at the end, the very thin bundle bound in red.
Yes.
So in terms of what we intend to do next, Your Honor, at paragraph 10 of Annex A, Your Honor will see the indicative timetable on how we intend to proceed. Assuming that leave to convene is granted, we intend to hold a joint meeting for creditors of both Zipmex Asia and Zipmex Singapore. We have targeted that as 22nd November 2023. This will be followed by a 2-week voting period. If the votes are in order, we will apply for sanction. And as to the sanction hearing, we have asked for an extension of the moratorium until 8 January to take into account court vacation. The sanction hearing can be scheduled anytime following our application for sanction, Your Honor, until the end of the extended moratorium. That's how we intend to proceed next.
All right. And it's a broad outline of the proposed voting, including the classes.
Yes, Your Honor. So let me start with 757. In 757, I have 2 classes of creditors. The identities of the creditors have more or less been crystallized. As Your Honor knows, this is a second scheme within this year, right? And there hasn't been much change to the creditor makeup. So I have 7 unsecured creditors voting in 1 class, 1 secured creditor, V Ventures, voting in the secured creditor class. The secured creditor holds share pledges over the shares of Zipmex Thailand and Zipmex Indonesia. So that's for 757. For 758, I have approximately 62,250 creditors. They are all unsecured and all be voting in the same class.
And how do you intend to run the voting for the 62,000 creditors? Could you summarize?
Yes, Your Honor. This will be done by way of an electronic stack form. So again, Your Honor, we have experience in this because we did the voting for the prepackaged scheme of arrangement. The technology works and we intend to utilize the same technology. We have a distribution list. The scheme managers will send out a copy of the electronic voting form, and then they can respond whether they are in support of the scheme, objecting to the scheme, or abstaining from voting on the scheme. At the same time, they are also free to send in the voting forms as an Annex C of each of the scheme, or in this case, you're on a Zipmex Singapore scheme. And they can send it in the regular way, and those votes will be counted together with any online votes that we receive electronically.
So regular way meaning by mail, I assume?
Yes, or by mail or email, Your Honor, to the scheme managers.
Yes.
Yes, Your Honor. So that deals with classification and voting. Under the Pathfinder test, I also need to satisfy the court that there's a realistic chance of the scheme being passed, and whether there is any allegations of abuse of process, if I may.
Yes.
In terms of the prospect of the scheme being passed, Your Honor, and for the purposes of full and frank disclosure, I have already mentioned earlier that there is an objection by VVI, who is a secured creditor. Now, if VVI's objection stands, and we cannot pass that particular class in the scheme of arrangement for 757, then it is more than likely that both schemes will fail. But there are reasons why I say that this position might not be as current as it seems on the face of it and on the face of their letter. If I may? Yes, Your Honor. So their objection is recorded in a letter dated 8 August 2023. So one thing from the very outset to take note is that this was in respect of the old scheme and not the new scheme that was annexed to our affidavits filed in September, Your Honor. The second thing is that the reasons set out in their letter are to us not very valid. First, they claim that they are a creditor of both Zipmex Asia and Zipmex Singapore. Now, we have been unable to find any link to them being a creditor of Zipmex Singapore. We have written back to them. Would Your Honor like to see the letters, or is that not necessary?
That's all right.
All right. So we've written back to them to ask them for verification of their status as a creditor. We have not heard back from them since. They also say that one of the reasons why they are objecting to the scheme in 757 is because they have further claims which should fall under the security. Again, we have written back. to inform them in no uncertain terms that the security was granted pursuant to an order of court. It was only for the sum of the super priority rescue financing. It shouldn't cover any further claims. In any case, the further claims which they say they have against Zipmex Asia are not very well particularized, and it is not possible for us to deal with them substantively, given the very limited allegations that are set out in their letter. The third reason why they say they object to the scheme in 757 is because they have an issue with the adjudication process. They say that the further claims they have necessitate trials and necessitate cross-examination of witnesses, etc., etc. Our position is that there is a process set out in the POTSA. We are not proposing to vary or substitute the entire independent assessor process. They can do that. If they are aggrieved, they can file a notice of disagreement, and the court will take it into account at the sanction stage. Once again, we've set that out in our letter. We responded to them on 11 August. Once again, we haven't heard back from them since. The final reason why we say that their objection, to put it bluntly, does not make commercial sense, Your Honor, is that they hold a secured debt of 4.6 million. The debt is secure over the shares of Zipmex Thailand and Zipmex Indonesia, which, as we have informed the court and creditors, we have negotiated term sheets the sale of. We are expected to fetch approximately 7 million USD from the sale of these two sets of shares. And we have put in the scheme that the proceeds will be used to discharge their secured debt first. All of that falls away if the scheme doesn't pass, Your Honor, because the scheme managers and the financial advisors have projected that if the company goes into liquidation, the shares are worthless because the Thai SEC and Bapepti might pull the licenses. So there's a very high chance that there will be zero recovery under the sale of these shares, and they would then prove for 4.6 million as unsecured. That, to our mind, Your Honor, is the key reason why we say that while they have objected on record, they have not come back to us since our clarification letter, and they are not present at this hearing today, Your Honor, to maintain this position. Commercially, this is not a position that, to us, makes sense. I could say more, Your Honor, but I think that would suffice in terms of the secured creditor's objection. Yes, Your Honor. In terms of 758, and maybe at this point, it would be good to take Your Honor to paragraph 41 of my written submissions. Again, Your Honor, is the very thin bundle in red.
Yes.
So here we have summarized what has been set out in the second and sixth affidavits filed in 757. So in terms of supporting creditors, I have 7. Total USD value 811,000. Percentage of total value 0.84%. Objecting to, I have missed that patch. 1 creditor, total USD value 656,000. Percentage of total value 0.68%. It appears to us, Your Honor, that a lot of the creditors are taking a wait-and-see approach on this. And perhaps it would be best, or at least we say it would be best, for them to be given the opportunity to vote on the plan with their feet, Your Honor. Now, to be absolutely clear, again, and as Ms. Siripon is in attendance today, this number does not include Ms. Siripon's purported objection. The reason for this is that Ms. Siripon, at least in our records, is not a creditor of Zipmex Singapore under 758, and perhaps the matters that she is objecting to might be better read as an objection to the extension of the moratoriums, especially over that, over Zipmex Thailand. And perhaps it would be best to deal with them then.
All right.
Yes, Your Honor. The last Pathfinder test I need to satisfy the court, Your Honor, is on the abuse of process point. And once again, the only allegations or allegations even coming close to alleging abuse of process are the emails from Ms. Depatch and Ms. Siripon. So Your Honor will see that in subsequent affidavits filed in 757, Yes, Your Honor, only in 757. We have responded to Ms. Depatch and Ms. Siripon's allegations of fraud, and also the very bespoke allegation that the sale of Zipmex Thailand is intended to enrich the Zipmex group. Would Your Honor want me to go into more detail on this?
No, that's all right. But could you just summarize your position as to the allegations of abuse of any possible assertion of abuse of process?
Sure. More than happy to, Your Honor. The first allegation that arises in Ms. Depatch's email is that we have committed fraud because we have used the 24 million loan from Babel to fund our business and operating expenses. So again, Your Honor, this does not come into consideration when we are talking about the process for the new schemes. Rather, it seems to be a historical criticism of how the business was run. In our affidavit in response, we have provided justifications and responses to it. Essentially, it is not a loan, it is a deployment from the Babel group that predated Zipmex's or Zipmex Asia's own deployments to the Babel group. Now, insofar as Ms. Depatch is alleging that we had used customer funds to fund this particular deployment to Babel, she is not mistaken. But under the Z-Wallet terms and conditions prevailing at the time, customers had agreed for us to hypothecate and lend. Basically, it is called staking, Your Honor. Basically, to stake customer assets to other crypto exchanges, including the Babel group. So for that reason, especially, we disagree with the allegation that there's been any fraud historically in the conduct of business. Now, as to Ms. Siripon's allegations, they are varied, but maybe the best way to approach it is this. She has in her emails provided to the court evidence that she has made police reports as well as complaints to the Thai SEC. Now, three things come to mind, Your Honor. First, under the scheme, she would not be bound by the release and discharge clauses. This is because she is not a creditor to Zipmex Singapore's scheme and not intended to be bound there. In any case, even if she was bound, this does not stifle her ability, or even the Thai police's or the Thai SEC's ability to continue with criminal investigations or regulatory investigations into the conduct of Zipmex Thailand. The schemes are not intended to stifle criminal liability, and it will be against Singapore public policy for the schemes to do so, Your Honor. We will not expect such a scheme to be sanctioned. The third thing is her allegation that the sale of Zipmex Thailand shares is meant to benefit the Zipmex group. The schemes are very clear. Proceeds from the sale of Zipmex Asia's holding in Zipmex Thailand will first go to pay off the secured creditor, V Ventures, and the balance will be used to fund the tranche 1 distribution, which is envisaged under both schemes, to apply or to give a small return to each of the creditors in both schemes within 120 days of the scheme effective date. That's the stated usage of the sale of Zipmex Thailand proceeds. It is not correct to say that we are doing it to benefit ourselves. In fact, she seems to think that if we do so, her claims will fall away. But, Your Honor, this is a case where Zipmex Thailand is being transferred. The shares of Zipmex Thailand are being transferred from Zipmex Asia to a third-party purchaser. The liabilities will presumably remain unless something is done to clear them in Thailand. And all criminal matters and regulatory investigations will no doubt run their course. We cannot affect the conduct of criminal investigations and regulatory investigations in Thailand. And I would just like to reassure Ms. Siripon that that is not the intention of the sale or of any group restructuring that we intend to pursue. Finally, and this goes back to the first point, if the objection is against the extension of the moratorium, the moratorium prevents actions from being commenced against the company and has extraterritorial effect. Again, it will not stop, nor is it intended to stop ongoing criminal and regulatory investigations over Zipmex Thailand in Thailand itself. And maybe I can leave that there.
Well, in any event, it will not stop her from pursuing what she wishes to do in Thailand unless she were present in Singapore thereafter, correct?
Well, yes, Your Honor.
All right. All right.
Yes.
Anything else on the extension?
On the extension, Your Honor?
Sorry, on the
Leave to convene.
convening application, sorry.
Yes, Your Honor. I think it behooves me finally to end with whether or not the scheme is fit for presentation. In this case, Your Honor, we have exhibited drafts of the explanatory statement, the scheme of arrangement, as well as all the exhibits. We will replace the financials with the July financials, which we have only just filed today, right? So before we issue, we will replace them. But otherwise, more or less in terms of finalization, it is good to go, and we target issue by 4th October.
Sorry, issue of?
Issue of the scheme documents, Your Honor, the scheme papers by 4th
All right,
October.
4th October. Thank you. All right, thank you. Anything else on convening? Mr.
No,
Tang?
Your Honor, unless I may be of further assistance.
Thank you. All right, I understand Ms. Siripon is present. I will promote her to a panelist to see whether she'd like to say anything. Ms. Siripon?
Yes, promoting.
All right, thank you.
Yes, declined to be promoted to panelist.
All right, you've declined. All right, so Mr. Pon, all right, I wanted to give you an opportunity to speak, but I understand you may not want to speak at this point. I also understand that there's been another email that you sent in, which I've just received with various attachments. Hold on a moment. Sorry, yeah, all right, I'll just read it out and I will forward this to the applicant's counsel after the hearing. You have stated, and this is sent to registry as well as CC to Ms. Deb Patch. Today you have just received additional information from Zipmex Group. Therefore, you would like to send your official documents from the Department of Business Development, Ministry of Commerce, an updated version dated 29 September 2023 to inform you that the financial statements for 2023 of Zipmex Company Ltd, i.e. Zipmex Thailand, have still not been submitted. The information received today cannot be confirmed to be true because the auditor has not yet certified these financial statements. All right, so that is the email you sent. I will forward this to the applicant's counsel after today, and I'll ask them to respond within a certain time frame. But in any event, you've, I think, heard their response, and that their position basically is that you are not a creditor of the scheme entities, and also that in any event, basically, the police reports and complaints and whatever investigations can still be pursued, and that, well, the moratorium extensions would not stop the police investigations in Thailand. All right, so that is the position taken by the applicant's counsel. I've taken note of your comments in the various emails, and I will turn back to Mr. Jonathan Tang to see if he has anything else to add in relation to the convening applications. Mr. Tang?
Nothing more from me now, Your Honor.
All right,
I will wait to see the email, and we will take instructions from Zipmex Thailand and respond.
all right. All right. Hold on a moment. Right, having considered the submissions and the affidavits and considering the law on the convening of scheme meetings, I am satisfied that sufficient grounds have been made up for leave to be granted. The factors are primarily concerned with fairness of the proposed meetings. I'm satisfied that the information disclosed, as well as the classification of the voting creditors, meets requirements of transparency and fairness at this time. I'm also satisfied there has not been any abuse of process and the proposed conduct of the meetings is fair. I therefore grant leave for the meetings to be convened. All right, moving on then, Mr. Tang, you had some variations to be approved.
Yes, Your Honor. Grateful for the orders made so far. If I may just turn now to OA 758, which is at tab 2 of volume 1 of the bundle of documents. So Your Honor will see at prayer 3 that we are asking for leave to vary or substitute the procedure relating to the inspection and adjudication of proofs of debt under section 6814 of ERDA, read with the ports, Your Honor. So if I can turn Your Honor to the ports, and I apologize for having to make so many references. This is tab 2 of the bundle of authorities. It's a medium-sized bundle in front of you, Your Honor.
Sorry, hold on a moment. Tab 2, yes.
Yes, Your Honor. So maybe we start with regulation 3, Your Honor. So we're asking for a variation of this because of the nature of the online voting, first of all. So regulation 3 prescribes that we need to send the list of creditors mentioned in paragraph 2 to every creditor who has filed a proof of debt. In sub paragraph 2 of regulation 3, it sets out that we must include the address of the creditor, the amount claimed, and a brief description of the nature of the claim under the proof of debt. Now, this is problematic for a few reasons, Your Honor. And apologies if there's some deja vu in this because I made this same submission before. In terms of naming conventions, Thai names are culturally unique. I am given to understand that there are very, very few scenarios whereby two Thai people have the same name. The majority of our customer base is Thai. There have been issues raised back in July or August last year, Your Honor, whereby there were complaints that the disclosure of their full names will make it very easy to locate them and their holdings. As such, very early on in OA 383, we disseminated a list of initial names together with their respective debt. And an example of this is set out in the affidavit itself. So this is tab 9 of the BOD. Page 161, Your Honor, of the bundle of documents, volume 1. Right at the top of the page, Your Honor will see what we did previously. To refresh Your Honor's memory, we sent out PDF lists to all creditors informed, right? So these PDF lists were very long. I think they are, as Your Honor can imagine, the PDF list was very long. So in relation to regulation 3, Your Honor, we propose that we will send out a list of creditors with their initials capitalized. The list will set out the indicated debt values, but will omit the creditor's address and the nature of the claim. Now, we turn also to regulation 7. Regulation 7 of POTS requires us to issue an updated list of creditors before the scheme meeting, and this list of creditors must be physical. Your Honor, as the meeting is going to be held virtually online, and it's a joint meeting. We propose that instead of a physical copy being disseminated, we send a soft copy through the distribution list
Mm-hmm.
prior to the meeting.
Mm. All right.
Your Honor, if I may.
Yes.
So now we go to the inspection protocol, and this is regulation 4. So POTSA prescribes relatively strict regulations as to inspection. But the key crux of this is that it requires one creditor to write to another creditor. So basically, the inspecting creditor has to write to the affected creditor. Because of the way we are doing this, we are anonymizing the creditor's names and email addresses. So instead of requiring that one creditor write to the other creditor, we propose instead that everything goes through the scheme manager, who will have the addresses of both the inspecting creditor and the affected creditor. The regulations that are affected by this particular request for variation would be for regulation 4 sub 1, regulation 4 sub 2b,
All right.
regulation 4 sub 4a.
All right.
We do not believe that any other variations of regulation 4 need to be made at this point, Your Honor. And perhaps, Your Honor, if I may,
Yes.
perhaps if it helps, if I can turn Your Honor to tab 2 of the bundle of documents, volume 1. That's our originating application, 758. At Annex B, page 21, we have set out at paragraphs 1 to 5 the proposed variations that we intend to make to POTSA. The only thing I would say here is that there is an inadvertent typo error at paragraph 4. It should read regulation 4, bracket 4, close bracket 4A of POTSA rather than just 4A.
Sorry, what paragraph was that again?
Your Honor, at page 22 of the BOD, paragraph 4, presently it says that despite regulation...
Oh, hold on. Sorry, I'm switching between multiple screens. Hold on a moment. You have to be a bit slow, Mr. Tang.
Apologies, Your Honor.
Yes, what was the reference again?
So it's page 22 of BOD volume 1.
Yes.
Your Honor will see that the sentence starts that despite regulation 4A,
It should be 4A.
it should be 4A. Yes, Your Honor.
All right. Thank you. So these are the only variations required?
Yes, Your Honor. 3, 4, and 7 of POTSA.
All right, hold on a moment. Very well, then the variations as listed in Annex B to the originating application in 0A758, was it?
Yes, Your Honor.
5758 approved including the amendment of para 4 to refer to regulation 4(4)(a). All right. All right then.
Yes, Your Honor, if I may proceed.
Yes.
Your Honor, the third bucket of applications are summonses numbers 2684 to 2688
Mm-hmm.
in OAs 381 to 385. These are applications for extension of the moratorium until 8 January 2024.
So these are all consequential, correct?
Yes, Your Honor.
All to 8 January 2024. All right.
Yes, Your Honor.
They're all in the same form?
Yes, Your Honor. I'm just double checking, but I
Yes.
believe so.
Well, then these are consequential extensions to cover the convenience scheme meeting and and the processes thereafter. I would therefore grant them in terms, order in terms for each summons, prayers 1, 2, and 3. All right. Anything further, Mr. Tang?
Yes, Your Honor. One thing in relation to formalities of the orders in OA 757 and 758.
Yes.
Perhaps if we will save some time, I would ask the court to open the submissions, first of all.
Yes.
Right at the back, there is a tab, Annex A. So this is page 30 onwards of the submissions.
Yes.
So that's one thing. And then the other thing I will ask the court to open is tab 1 of the BOD, which is OA 757.
Yes.
So in terms of prayer 1 of OA 757, Your Honor, we will be seeking orders in very, very minimally modified terms. So prayer 1 says, pursuant to section 210(1) of the Companies Act, etc., etc., leave be granted to the applicant to convene a joint meeting. So we propose the insertion of the word joint.
Mhm.
Your Honor, if I may,
Yes.
bracket the scheme meeting
Hold
of
on right there. What is the actual thing? Hold on a moment. It could be a joint meeting.
a joint
Read
meeting.
out the whole thing to me first.
Yes, Your Honor. Pursuant to section 210(1) of the Companies Act 1967, bracket the Act, leave be granted to the applicant to convene a joint meeting, bracket the scheme meeting, close bracket, of 2 classes of its creditors. This is just for accuracy's sake, Your Honor. No other changes are proposed.
So this is just to facilitate the holding of the joint meeting, right? Basically in the way you've outlined your submissions, correct?
Yes, Your Honor.
No, so there will be no prejudice to anyone.
No, there will not be.
Let me just type out the whole of the first section. All right, so to convene a meeting, bracket, open bracket, the scheme meeting, close bracket, of
2 classes of
2
its
classes of its
creditors.
creditors. All right. All right, thank you. All right. I'll allow the amendment.
Grateful, Your Honor.
All right, something just struck me though. In relation to the meetings, how will the creditors be able to communicate with each other if they wish to consult?
Presently, we are thinking that the meetings will be video streamed, but comments will be disabled.
Sorry,
Perhaps,
to put comments in.
but comments will be disabled.
All
But
right, yes.
perhaps if this would satisfy the court
All
as
right.
to communication, we could enable comments.
All right. Means in any event, you have a 2-week gap, was it?
Yes, Your Honor, there's a 2-week voting period following.
All right, can I specify this? Yes, the comments are to be enabled at the video meeting. And any and creditors are to be told that sorry, let me phrase it. And creditors may send in comments for distribution by the scheme manager within the first 3 days. Let me see how I should structure this. All right, I'll have to impose it upon the scheme manager to do this. Creditors sending comments by the scheme manager will distribute the comments to all creditors every so it was 2 weeks, right?
Yes, Your Honor.
Every 3 days until the 9th day. All right. Of the sorry, what do you call that period again? Voting period.
Voting period capitalized.
Right. So basically, creditors may send in comments for distribution by the scheme manager, but the scheme manager basically only needs to distribute it every 3 days until the 9th day.
Yes,
All
Your
right. So basically 3 days, and that's at the 3 days. I think that would be fair enough.
Grateful, Your Honor. In that
Alright, so-
case,
Mhm.
apologies.
Yes.
Maybe now it will be opportune to turn to the Annex A, which I had
Yes, all right.
directed the court to earlier.
Yes.
So I had originally directed the court to this because I wanted to annex this amended Annex A to each of the orders of court in 757 and 758.
Yes.
But after hearing what the court has said, perhaps I can suggest that for the purposes of paragraph 2 of the annex, we will delete the terms, we will delete the phrase with comments disabled.
All right. Annex A, para 2. You delete the comments disabled. All right.
And we add in a new paragraph 3.
Oh, you got para 3 there, but but that,
Apologies, Your Honor. We will add in a new paragraph after paragraph 2. And
yeah, maybe for the time being, new para after 2. All right.
yes, and that paragraph will read,
Mm.
comments are to be enabled
Mm.
at the online meeting,
Mm-hmm. Yes.
and creditors
Mm.
are to be told
Mm.
that creditors
Mm.
may send in comments
Mm.
for distribution by the scheme manager
Mm-hmm.
within the first 3 days,
Mm-hmm.
who will then distribute
Mm-hmm.
the comments
Mm-hmm.
to all creditors every 3 days until the 9th day of the voting period.
All right, so that would seem to mean that they should only send comments in the first 3 days.
Yeah, maybe I heard your.
No,
It's
no,
just
what I
struck
was
me,
thinking of was that they send in the comments, but the creditors only has to distribute the comments every 3 days. So basically the creditors are allowed to comment until the 9th day. Sorry,
Understood. Your
until
Honor.
the yes, until the 9th day, basically.
So if that's the case, maybe I can read out this new paragraph.
Yes, all right.
So comments are to be enabled at the online meeting,
Meeting,
capital
all right.
O, capital M,
Mhm,
and creditors are to be told that they
mhm,
may send in comments
mhm,
for distribution by the scheme manager,
mhm.
capital S, capital M,
Yes,
who will then distribute the comments to all creditors every 3 days
mhm.
until the 9th day of the voting period.
All right.
Apologies, Your Honor. Instead of scheme manager, why don't I put chairman?
A chairman, all right.
Yeah, as defined below.
All right. I think that
Yes.
will work. All right. So basically, I would like the chairman to take in the comments and distribute it every 3 days. I just wanted to spare him or her having to distribute the comments every single day.
Yes.
All right. All right. Then I would assume thereafter the creditors who may need to consult will have worked out some other way of communicating with each other. All right. Thank you. All right. Anything else, Mr. Cheng?
No, Your Honor, save that this amended Annex A will be annexed to both orders of court in 757 and 758
Alright.
in replacement of the existing Annex A.
All right. All right. New Annex A is amended to be attached to the orders of court. All right. Anything else?
Nothing further from me, Your Honor.
All right, we'll see how things pan out then. All right. So anyway, I've given you liberty to apply. So if any further complications arise, you may apply to the court. Otherwise, if nothing further, thank you. Court is adjourned.
Thank you, Your Honor. Good day.
Good day.
Court is adjourned.